Hello and welcome to this informational video. My name is Arnie. I'll be your host for this interview. With me, I have a special guest, a very knowledgeable person on this topic of wills this time. May I introduce to you Mr. Atif Nanji.
Hey, thanks for having me back.
Thanks for being here. I really appreciate this. We've had two great interviews on health representation, then on power of attorney. This one's going to be a tough one. This is wills. This is the one that probably most people are interested in, and rightly so. Blah blah. And so I wanted to do this one specifically, but I added the other two because they're all equally important as far as the estate planning is concerned. So, let's get to the meat of this one. What is a will?
So a will is a document that allows you to guide what happens to, how your estate should be managed when you pass away. So you can name executors, which are the people that are going to manage the estate. You can name guardians if you have minor children, and you can decide how you want your assets distributed and among whom.
Okay. So a will happens or takes place after the person passes away.
Right, yes.
Right. Where all the other documents were prior to passing away.
Exactly.
Okay. All right. So we kind of answered this question before, but we're going to do it in a reverse way here. What is the difference between an enduring power of attorney and a will?
So a will is strictly for after you pass away, whereas an enduring power of attorney would be strictly for while you're alive.
Okay, all right. I know we've answered that question, but some people might only be watching this video, so we have to kind of overlap a little bit.
No problem.
All right, we're going to get into terminology. And there's going to be words that people are not familiar with. I know I've struggled with it for years, and I'm starting to understand some of the wording. Some people just viewing this video for the first time might still be struggling, so we're going to help them through some of the terminology. What is an executor?
The executor is a term that's generally used for the person that's going to manage the estate. They can also be referred to as a personal representative, and sometimes a trustee. But so the executor is the one who's going to gather all the information about the estate. They're going to typically be the one who arranges the funeral. They're going to be the one to notify your banks and the government and other institutions that you've passed away, provide them with your death certificate. And ultimately, they'll be the ones to divide your estate, and which may require applying for a grant of probate from the courts.
Okay, that's good. So in assigning an executor, maybe I should ask this question first. Can you have more than one executor?
Yes, you can have co-executors, and you can have successive executors, like a primary and an alternate.
Okay. Okay. I know with my brother and I, we were equal executors in my dad's will. Okay, so when we talk about executorship, we want to talk about trust, capability, residency, successive executors or co-executors. That's kind of where I asked that question.
Yeah.
So
I think so. Trust is the most important thing, as it's been with all the documents that we've been talking about. Anybody you're appointing to manage your affairs, you're going to want to trust them. Followed closely by capability. You want to make sure they're going to be capable of dealing with your assets. So depending on the complexity of your estate, you may need to consider who you're appointing and whether they're going to be capable of understanding, how to deal with, let's say if you have corporate assets, for example, how to deal with that. If you have assets in different countries, are they going to be able to deal with that kind of thing? And even more so than the other documents, location is going to be very important here. Ideally, you don't want to appoint somebody that lives in a different country because there could be additional tax implications there.
Oh, okay.
Whereas they would not have those issues. The executor would not have those issues if they lived in Canada. And even living in a different province can sometimes cause some issues. So ideally choosing someone in BC. That's probably, the location is probably most important when it comes to a will versus a power of attorney or representation agreement.
Okay. I just thought of this question. If a person takes on the executorship, and I'll just use the example, okay, they're middle-aged, but the person who they're going to be the executor for lives a long time. That means you're going to be much older.
Yeah.
Now, the person can change their executor to maybe appoint somebody much younger, okay? But let's say that never happened, and the person passes away, you become the executor, but you just feel this is just overwhelming. Can you say, for an example, go to a notary and say, can you be the executor, or go to a lawyer and ask them to be the executor? Like, is there an avenue for them to go?
Well, you can't really transfer your appointment to somebody else. You can, so number one, if you feel like you're not up to the task, you can renunciate your executorship. It's basically a fancy term for resigning.
Okay.
So you basically step down, you sign a piece of paper saying you're renunciating the appointment, and then if there's another, like a secondary or alternate executor named, then at that point they would step in.
Okay.
Let's say it's a situation where maybe you just, where you're okay being the executor, but you just are not okay doing all the paperwork because it can be complicated. So if in that situation, you can simply hire a lawyer to do the probate application for you. They're going to do most of the work, but you'll still be the named executor and the person essentially in charge.
So you oversee these subcontractors, so to speak.
Yeah,
Okay.
yeah, that's a good way of thinking about it. And then let's say if you cannot act and there's nobody else able to act, and if you and you want to renunciate, then the Office of the Public Guardian and Trustee would have to step in. But that's something that would be considered like a last resort.
Okay.
It's not ideal. They do charge, I believe, hefty fees, more than most executors would charge for that.
Yeah. And what did you call that? The Office of what?
Of the Public Guardian and Trustee. So it's a government institution, and they also deal with power of attorney issues, but sometimes they also act as personal representatives on estate matters as well, when there's nobody else able to act.
Okay, interesting. I've learned something new. Yeah. This is good.
Also, somebody could also apply to be the administrator of the estate. So, sorry, I should have mentioned that. So let's say somebody passes away, they've named executors, but all the executors are either unable to act or they're unwilling to act. So another family member can actually apply to take over. The process is a little bit different, and it's called administrating the estate with the will annexed, which it doesn't happen very often, but I've certainly seen it before.
Oh, okay, interesting. All right, I'm going to throw another word at you that I know everybody that's watching this video, including myself, okay, has trouble with. The word is simple, but the meaning is difficult.
I think I know what you're going to say.
I'm sure you do. Probate.
Probate, and I don't blame you, because probate is, as a term, is thrown around quite loosely. But usually when we're saying probate, we're referring to the general process of applying for a grant of probate. So it's like an application process with the court. So when you're applying for probate, you're submitting the will maker's original will, along with some supporting documentation. There's some affidavits that have to be filled out and signed. And you basically submit this package to the court as part of an application for a grant of probate. What the grant of probate is it basically, when you receive it, it appoints you as the official trustee of the estate, and that allows you to start transferring assets out of the deceased person's name into your name, but as a trustee, and that allows you then to start selling those assets or dividing them up among the beneficiaries of the will.
Okay. I've heard, and again, this is through the rumor mill, all right, that you do not have to go through that probate process if the person who's passed away has, I'll say, $10,000 in assets or less?
Yeah, there is something to that. as per the legislation, if a small estate may not require probate. A small estate is considered anything $25,000 or less. However, it can depend on the gatekeepers of the asset as well. For example, land is a good example. So if a person owns a piece of property, whether it's a piece of bare land, a condo, a house, even a manufactured home, even if it's worth less than $25,000, like let's say it's worth $5,000, $10,000, you still have to go through probate before that asset can be transferred from the deceased name. So that's a good example of one of those exceptions to that small estate rule. Another can be if the gatekeeper of an asset simply decides it to be so. And banks are a good example, or financial institutions.
Right.
So if and it can go both ways. So for example, if let's say an account's worth $10,000 and that's all that's left in the deceased name, so you're thinking you can get you can avoid probate, but if you go to the bank and say, could you please release this asset to me? I'm named as the executor and I intend to distribute it among the beneficiaries, the bank could simply say, no, bring back a grant of probate. And there's really nothing you can do about it.
Right.
You can press them, but if they hold fast, you may end up having to apply for a grant of probate simply to deal with that asset.
Sure.
I've seen this happen for particular investment companies, especially the ones that are based in the United States. Another example is, well, on the flip side though, some banks have a higher threshold for requiring probate. Certain banks have a $100,000 threshold. So that means that an account could be worth $80,000, and they may simply release it to the executor without a grant of probate. They might want the executor to sign some forms of releases or waivers, but that's better than having to go through the probate process.
Sure. Yeah. And there's a lot more paperwork involved releasing property.
Yes. Yeah.
So you want to make sure everybody's got their I's dotted and their T's crossed to make it all legal.
Yeah, so once you have a grant of probate, first the property has to be legally transferred into the executor's name as trustee for the estate, and then the property can be transferred from there to a seller or to the beneficiary. So there's 2 transfers involved typically.
Right. Yeah. Okay. Interesting. Okay. So are there fees involved with probate?
Yes, probate fees are based on the value of the estate. Luckily, they're lower than most people think. They're about around 1.5% of the gross value of the estate.
I thought you were going to say 30, 40%.
No, it's not like estate tax in the U.S. Here, there's probate fees, which is kind of could be thought of like an inheritance tax, but it's so small.
You hear all these people saying, I'm going to avoid probate so I don't have to pay the government any monies.
Yep, I hear it all the time.
1%, that's nothing.
Yeah, and I tell people that all the time. People come in wanting to do property transfers or all kinds of things to avoid probate. Usually these things can create more risk than it's worth, and many of these people are not aware of what the probate fees actually would be. So,
right. Good point. Yeah. Yeah, we're always trying to give the government less, aren't we?
Yes, don't blame them.
We're not thieves, we just don't want to pay. We're greedy, we're cheap,
people work hard for their money, and they want to make sure their kids get as much of it as possible.
Exactly. Yeah. All right. We're going to need a definition on this one. The word estate. What exactly is an estate?
So your estate would be everything that you own at the time of your death, except for assets that wouldn't fall into the estate. And examples of those would be assets that are jointly held with another person, such as jointly owned property or a joint bank account with survivorship rights. And the second example would be assets with designated beneficiaries. So things like registered investments like RSPs, TFSAs, where you've named a beneficiary, like at the bank, for example, or life insurance policies where you've, again, named a beneficiary. So those assets would not flow into the estate. They would go directly to the beneficiary that's named after you pass away.
Really?
Yeah, so they would bypass probate fees. So it's important to know that.
That is interesting. Interesting. So liquidating your assets and assigning, say, a bond or whatever to a particular person, or not necessarily a person, maybe an organization, would be beneficial because they wouldn't have to pay tax on that.
Not necessarily they wouldn't have to pay tax, but they wouldn't have to pay probate fees.
Oh, probate
or
fees,
the estate
okay.
wouldn't pay probate fees on it. So
Right.
yes, that is something worth considering. Adding people as joint on accounts is sometimes can be a good idea, especially between spouses.
Right.
When thinking of, a lot of people will add their kids, which can sometimes be a good idea.
Sure.
But when it comes to adding children to accounts or children to the title of the home, it's not so black and white. I think there's usually a long discussion that happens at our office, especially with the title stuff,
Right.
before somebody moves forward with that.
So if you assign, say, a bond or bank account or whatever the case might be to a particular individual, but let's say, for example, that individual doesn't belong to the family. Let's say, for an example, they got 3 children and they didn't get bonds. They got other assets, but not bonds. Could the children contest that part of the will?
They can only, so when it comes to contesting an estate, like when we're talking about contesting, there's usually 2 ways people will contest an estate. One is, the most traditional way is something called a wills variation claim. So only spouses and children can make that claim. And it's usually when a person feels like they have not been adequately provided for by the will, usually when there's an uneven distribution. But they can only make a claim against what's in the estate.
Wow.
So if those assets that you're referring to have designated beneficiaries
Right.
and it's not flowing through the estate, then they wouldn't be able to make that kind of a claim. Now, there's another kind of action they could bring forward. They could try to argue that the designated beneficiary of, let's say it's a TFSA, for example, high value TFSA. So they could try to argue that the beneficiary is not the true beneficiary of that asset, but they're simply the trustee of that asset. So in fact, the asset does belong to the estate. So what the person making the claim could try to do is bring that asset back into the estate and then make a claim against it.
I see.
Yeah.
Okay.
So the key thing is whether it's in the estate or not.
Oh, okay.
Yeah. So
Okay.
and what I'm talking about there is that that concept is something called resulting trust. So when you add somebody to an asset, there can either be a presumption that it's a gift or that it's a trust. And that presumption will depend on the relationship between the 2 people and also any supporting documentation.
Okay, interesting. Okay. There's a lot more that can be said about this particular topic of estates. I'm going to leave it at that because everybody's scenario is going to be different on how you write up the will and how it's executed, contested or whatever down the road. So let's leave it at that because that's when people should come and see you or a lawyer and get it written up properly.
Sure. Yeah.
Right? Because I'm going to, if I continue on, I'm going to ask questions that are going to seem absolutely stupid because I just don't know this area very well.
Please do. It'll make things interesting.
Yeah. Okay, so when we talk about the estate, we talk about assets. Can the assets be in a different country or a province? Like, for an example, like I own property in Mexico, but I live in Canada, or in particular British Columbia. Can those assets be included into the will?
They can be. However, normally I recommend that if a person has an asset in a different jurisdiction, such as property in the US or in Mexico, the standard advice is that they should have a will in each jurisdiction where they have property or assets.
Oh, really?
Yeah, so in those situations, what I normally recommend is that we do a will for their Canadian assets, and we specifically say that it's just for their Canadian assets. And then they would get a will down in the, let's say if it's down in Arizona, they have a condo, or maybe in Mexico. I say next time you're down there, make a will, but make sure when you make your will down there, you're limiting it just to that jurisdiction. So Mexico, they would want to have a statement in the will saying this is only to deal with my Mexican assets and shall not revoke any other wills
Right.
made in other jurisdictions.
Good point.
Yeah.
Good point. Would they come to your office to get that separate will for that asset? Or do you have to go to, say, Arizona and get a notary there?
They can't get a will for a different jurisdiction. We can't do that at our office. So I'd recommend they get that done in that, wherever their assets are.
Oh, okay.
Yeah, next time they're down there.
Okay. And I'm assuming now that if you go to a notary or a lawyer down in, say, Arizona, have that will done up because you're not a citizen of that country, that's a legal document?
Yeah, it's still a legal document, yes. You don't
Okay.
have to be a citizen of a country to make a will there. What's most important when it comes to where you should make your will, deciding where you should do it, is the question of where your assets are located.
Sure. Okay. That's a good point. I never even thought about that one. Boy, oh boy. The things we learn.
Yeah, I mean, it is possible for a will done here to be used for probate in another jurisdiction, but a couple issues with that. Number one, wills legislation varies from province to province and country to country,
Yeah.
so there's no guarantee that a will made here is going to be considered valid in another jurisdiction.
Sure.
I mean, most of the time the requirements are the same, in terms of witnessing and things like that, so usually that's not the big issue,
Okay.
but that's certainly a concern. But the other issue is that probating a will simultaneously in different jurisdictions can be problematic for other reasons.
Okay.
Yeah, we don't do any probate work at our office, so I don't know the kind of the nitty-gritty ins and outs of it.
Right.
But I just know that it can be problematic. So
Right.
it's certainly recommended by lawyers and notaries to have separate wills.
Well, I'm sure the viewing audience of this video did not have any clue that you'd have to have a will done in each of these jurisdictions,
Yep.
even province to province.
Yeah, most people don't know that.
Because we think Canada, it's all the same.
Yeah. Yeah.
North America, we're all the same,
Yeah.
but we're not.
Yeah.
Legally, we're not the same.
At least our laws aren't the same.
No, that's right, yes. Yeah, okay. All right, so this is an interesting question I have here. What happens if someone dies without a will?
So if someone dies without a will, it's called dying intestate or an intestacy. And basically the distribution of, so who can act as executor will be determined by, there's a ranked list of who can act. And it's, basically family members ranked with regards to their proximity or, closeness. So that's for executorship. In terms of the distribution, that's also legislated. So, and this is where it gets interesting. So let's say you are a married couple and you have 2 children. So you would think that if you pass away, everything would go to your spouse, and when you're both gone, then everything would go to the kids. But when you die without a will, actually what happens is something called a preferential share is entitled to the spouse, which is $300,000. And the remainder of the estate gets split in half, with half going to the spouse and the other half going to the kids. So that means the spouse does not get everything right away. This can be a particular problem if all that's really the person dies with is a house. So now, and let's say there's no other assets, now that house may have to be sold in order to split the funds up between the spouse and the kids. So it can be a real problem. Now, if let's say the person who passed away had children from different marriages, so their spouse is not let's say the spouse is not the mother to all of their children.
Yeah.
That preferential share then gets cut in half.
Wow.
Now the spouse only gets $150,000. And the remainder gets split between the spouse and the kids.
Wow.
So yeah, again, probably not what the the deceased had in mind or intended to happen. So that's why it's very important for people to get wills done, even a basic will, even if they have a very simple estate and very simple family situation.
Right.
A very simple will can still be very helpful.
Wow. Wow, you just gave me a whole... I don't know what else to say. I mean, I'm boggled, by that, because it just opens up so many questions.
Yeah.
I mean, this whole topic on wills, is so complicated. So, just a quick question here. the person dies without a will. They've got kids. They've got brothers and sisters, or brothers and sisters, I should say, who are going to look after that business, okay, without the will. Do they have to apply to the court for them to be the executor, representative? What do you call them at that point?
Very good question. So it's they would be called the administrator instead of the executor.
Okay.
And it's called applying for a grant of administration as opposed to a grant of probate.
Okay.
Very similar process, just a little bit of different paperwork involved. You know, maybe a couple other hoops to jump through, but it's basically it's quite similar.
Sure.
Yeah.
Okay, interesting. Wow.
So instead of probating the estate, you're administrating the estate. So
Okay.
just semantics, basically.
Yeah, exactly. All right, next question. Can the government get my estate?
Yeah, so it's possible, but highly unlikely. So
Okay.
we're talking about a principle of, there's a principle in the law where if you pass away, leaving, and let's say you don't have a will, and if you have no heirs, and I believe it's all the way up to descendants of your great-grandparents.
Whoa.
So we're talking like, I think, to the 5th degree.
Wow.
Like if there's no family, then at all, then it would flow, then your estate would flow to the government.
Okay.
So for most people, they're gonna have somebody in that family tree that's going to be able to take that.
Okay.
take
It's
the
just
estate.
finding those people.
Yes, so there are services that are out there that are dedicated simply to doing that. It's called genealogical searches.
Oh, yeah, I've heard of them.
I used to work for a company that that did tracing,
Okay.
and they had a genealogical search wing.
Okay, okay. I mean, I've heard of the Genealogical Society, but it's more of a fun group of people that, that want to know about their ancestry.
Oh.
Not their ancestry to find out who to give their estate to. More like for other reasons, All right, so we have an estate, and now we have to talk about how to distribute an estate. There's many ways that I've got listed here. Specific gifts, monetary gifts, gifts of residue, alternative beneficiaries, gift of firearms. And that one really throws me. I'm not sure. Well, I'll let you answer this.
Gifts of firearms, I think legislation's changing there. I mean, for non-restricted firearms, it's simply just, I just recommend people gift them to somebody that's got their license.
Okay.
And that intends to keep their license.
Sure.
Alternatively, if they don't include a provision in the will specifically gifting their firearms to somebody, the executor still has limited powers to possess and transfer those firearms
Okay.
Within a certain period of time, or they can surrender them to the RCMP. So if the will maker doesn't include a provision regarding firearms, it's not the end of the world. But ideally, we would want to specifically gift them to somebody who's authorized to possess them.
Qualified.
Yes. Yeah.
Yeah.
What was the other question?
Okay, there is specific gifts, monetary gifts, gifts of residue, alternative beneficiaries.
So the firearms would be an example of a specific gift. A specific gift is anything specific that you want to gift to a particular person. So it could be firearms. It could be a vehicle that you intend, like maybe a classic car.
Mm-hmm.
It could be a piece of valuable artwork.
Sure.
Jewelry. Those are. It could be anything. Mom's fine china.
Yeah.
These are all kind of the common examples of things, but it could be anything of significance or sentimental value usually.
Okay.
Or importance to the child that it's being gifted to. So that would be specific gifts. Cash gifts, simply just gifting cash. Some people want to, let's say, give, when they pass away, they want each of their grandchildren to receive a certain sum of money. So that might be an example of a cash gift.
Okay.
Gifts of residue is simply anything that's left over after any cash gifts, specific gifts, and debts are paid.
Okay.
So basically anything that's left over forms the residue of the estate, and normally I recommend people divide that up using percentages or shares. And then
You're talking about like amongst the the beneficiaries,
Right.
like the children.
Yeah, usually it's the children that are the residuary beneficiaries, but it can be anybody. You know,
Okay.
for people that don't have children, they may want charities, friends, or other family members to be those
Or include a
beneficiaries.
caregiver.
Sometimes, yes.
Sure.
Yeah.
Or search and rescue.
Yeah.
Yeah, like,
Yeah, in terms of charities, you know, many people include charities as well.
would that be an alternate benefit?
It can be, yeah. So usually when I see charities, it's going to be as in what we call a disaster clause. Let's talk about alternative beneficiaries first. Most people are going to have their primary beneficiaries, and I always recommend we talk about what happens if that beneficiary predeceases you.
Ooh.
Where does their share go?
Yeah.
So that's the alternative beneficiary. So for let's say for 90% of the wills we do, couples are first giving everything to each other. Then if they're both gone, they're giving it equally to their children.
Sure.
And then if one of their children passes, that child's share will go to their respective children.
Okay.
So that's kind of, the grandchildren would be kind of the alternate beneficiaries at that point.
Okay.
Now the disaster clause is something else, and that's something that we do a lot for younger families, especially. But that basically says what happens if all your beneficiaries that you've named are all predeceased you, then where does everything go?
Mm-hmm.
And usually that's where we'll have more distant family members, or sometimes churches, charities, other organizations, things like that.
Sure. Yeah. Okay. Wow. A question for you that, just speaking of like distributing the estate, if you had an executor who was a family friend, but was not listed as a beneficiary, in other words, in the will they get absolutely nothing, but they're doing all the work, could they be an alternate beneficiary? Or maybe onto a different topic, would that executor be entitled to some remuneration for their time spent?
Yes. So sometimes, so whether an executor can be a beneficiary, quite often, let's say, in the example I gave before of like the nuclear family doing a will, so most of the time the spouses will appoint each other as first executor, and they'll appoint one or more of the children as the backup executors, and these people also happen to be beneficiaries of the will as well.
Right. Okay.
So it's not unusual for the executors to be also the beneficiaries. Sometimes if appointing a friend, I have seen people specifically give a gift to that executor in exchange for acting. It could be a certain sum of money. Usually it's a certain sum of money, or it could be a designated percentage of the estate. Now, if there's no such gift to the executor can still receive compensation for acting. They're entitled to claim a maximum of 5% of the gross value of the estate.
That's more than the government was getting for the probate.
Yes. Now, they may not be successful in claiming that amount. I think while the maximum they can attempt to claim is 5%, I think in majority of the time they're getting around 2 to 3%.
Okay.
Yeah.
Okay. Who do they apply for that cost or that benefit? Like, I'm not sure what to call it at this point. A fee for their services? Like, do they? Well, they're going to obviously approach. No, they're the executor. So who? They can't just sort of write a check to themselves, can they?
No, I believe they have to include it in part of their probate application. Yeah, I think I think the court has to approve it.
Okay. I keep forgetting about the probate part. Yeah. All right. Well, those are good answers. My goodness, like my mind is just boggled. I'm gonna have to go back over the website information on the detailed answers that you've put on the website. Just to wrap my head around this, because unless you deal with this every day, this is mind-boggling. It really is. You make it simple, but in actual fact, if I was to try and explain this to somebody, I'd be tongue-tied.
Well, dealing with every day certainly helps. So.
Yes. Okay. Oh my goodness gracious! This one. This is a troubling one, but I got to ask this question. Can the person that passed away that did the will, can they leave one or more children out of the will?
They can. So the way disinheritance in BC works, there's no law against disinheriting a child or giving them a smaller share.
Yeah.
What the law does say, though, is that if a child or spouse feels like they have not been adequately provided for, that they can make an application to the court and request that the will be varied. Varied meaning changed.
Okay.
So basically, a child that feels like they've been left out, they can ask for more.
Mm-hmm.
Doesn't mean they're going to get it, but they have the right to try. And when I say child, it's important to note that we're only talking about natural and adopted children. Unfortunately, stepchildren do not fall into that category.
Interesting point, because a lot of families now are mixed families from one or more parents.
Yeah.
Yeah.
No, so that's so something really important to note that might be of interest to some people is that, so let's say in a situation where there's now a blended family. So
That's the word, blended. That's, yeah.
So let's say dad passes. Let's say my dad passes away, leaves everything to his new wife, who happens to be my stepmom. Stepmom then goes and changes her will and makes her kids the only beneficiaries, so cuts me out. And then she passes away. I can't make a claim against her estate. Because I'm not her child, her natural or adopted child. Now I have no recourse.
And we've had friends that fell into that absolute category.
Yeah, I've seen it
they got
many times.
nothing. $1 million estate, and they got zero.
Yeah.
Wow.
It is an unfortunately common thing to happen.
Wow. Gee. Yeah, it troubles me just to talk about that, but it does happen. It does happen. Okay, man.
There are ways to protect against that, by the way.
Is there? Please do tell.
Well, it comes. So there's something called a spousal trust that can be set up, where let's say let's say you come into a new relationship and you're holding most of the assets. And when you pass away, you want your spouse to be taken care of, but you don't necessarily want everything to be entitled to the spouse. You want to make sure that there's something left for the kids when the spouse either passes or no longer needs the money. So you can set up something called a spousal trust rather than gifting everything to your spouse.
Okay.
You can set up a trust which is solely for the benefit of the spouse. That means so all their expenses gets paid for until they either pass away or get remarried, and upon either of those events, any money left over then goes to the beneficiaries, which would be probably your children in that situation. Okay. But it's important to note that notaries can't do those kinds of trusts. You have to see a lawyer for that.
Right.
Yeah.
Yeah, because it's more complex and
yes,
the legalities involved, and yeah. Okay. Whoa. Wow. Okay, so two sub-parts of that question about leaving one child or more out. Will's variation claims. Did you cover that, or?
Yeah, that's what we're talking about, the ability for spouses and children to make a claim against the estate if they haven't been fairly provided for. That's what we call a will's variation claim.
Okay, you just didn't use that terminology, so that threw me.
Oh.
Yeah, but don't feel bad. It's all on me. I'm the one that has to learn this. You already know it. Token gifts. What are token gifts?
So when I say token gifts, so let's say some people are under the impression that if they're going to leave a child out, that if they give them $1 or $10, that's going to take away that child's ability to make a claim or the will's variation claim.
Yeah.
What I would call a token gift. And that's false. Regardless of how much you give a child, if they feel like they haven't been fairly provided for, they can make that claim.
Okay, good to know. Because through the rumor mill, I'm just going to leave my child $1.
Yep.
And there's not much they can do about it because that's what my wishes were.
Oh yeah, I can't count the amount of times I've heard that from people. Like they come in and they're set in what they're going to do, and
yeah,
and then they tell
not
me,
knowing the law.
And it's always somebody told me, or a friend told me, or a neighbor told me this or that. And,
yep.
And I have to sometimes correct them.
Okay, all right. This is an interesting question. Because we talked about in health representation, we talked about in the power of attorney, changing those documents. In the case of a will, can you change it?
Yeah, so most changes are going to require a brand new will, but there is a way to formally amend an existing will. It's called doing a codicil.
Okay.
But codicils are becoming less and less common these days, especially since now most wills are going to be saved electronically at your notary or lawyer's office. Okay. It's much easier for me to go in and it's not only much easier, but it's also a lot cleaner for me to just go into the old Word file, update the information that requires updating, make the changes that are requested, and reprint it and sign a brand new will.
Okay.
Yeah.
Yeah. That just triggered another question. We always talk about the will being registered. Is it registered, or is it just stored in your office, so to speak?
Well, both. Depending where you get it done. So most legal offices are going to register the wills. When we talk about wills registration, we're referring to the wills registry, which is run by the Vital Statistics in Victoria.
Okay.
So yes, we register all of our wills. We also store electronic copies of the wills on file at our office. I think most law, legal, law and notary offices are going to do the same thing.
Okay.
Wills registration, it's important to know, though, that it's not necessary or required to have a valid will. It's completely optional, but certainly recommended.
Okay, good to know. Because if somebody dies, you go to the Vital Statistics office and you get them to do a search, they're not going to be presented with the will. They're going to be presented with your office information on where the will is?
They'll be presented with not necessarily our office, unless we're holding the original. It's more about where the original will is being kept. Okay. So let's say if you're keeping it at your safety deposit box at the Bank of Montreal at Eagle Landing, you'll see that address in there. Okay. Or if you're keeping it at your home, you'll see the home address, from the time you made your will. Okay. So that can sometimes be a problem if people move their will, or they move house and they don't update the will's registry. Right. But usually, if the executors are the children, normally they're going to be aware of where mom and dad might have moved things to, but they don't always tell the kids where they moved the will to. Yeah, yeah. Yeah, if they moved it to a different, let's say they downsize, and before it was kept in a particular place in the house, the kids, unless the parents make sure the kids are aware of where it's now being kept, they can sometimes be, tearing the house apart looking for it. I get a lot of calls from kids who say like, oh, where's my mom's will? Do you have it? And I'll go into the file after I confirm that they're the executor. I'll go into their file and I'll say, oh, well, according to our records, it was being kept at the safety deposit box at this bank. Oh, mom shut that down years ago. Oh. And then I'm like, oh, do you know where all those documents went? No. Or mom, or this, according to our records, it was kept, at this house. Oh, mom left there years ago and moved into assisted living. Right. Then I'm asking, where did she have a box with documents? Where else might it be? And I can't really help much at that point. No. So if the executor or somebody, was looking for the will, went through all of those avenues, still couldn't find it, is there a time frame that they have to wait before they can apply to the next phase of taking care of that estate? I don't think there's a time frame, but there is a way to, if the original can't be found, there is a way to submit a copy in lieu of the original to the court. Okay. It's another special application. There's no guarantee the court will accept it, but there's a pretty good chance they would, as long as there's a very good explanation. Sure. And as long as the court was certain that it was the most recent, the copy that was being presented to them is in fact the most recent will. Yeah. It's becoming, the courts, there's a general trend of the courts becoming more lenient in what they will accept as a valid will. Okay. Due to this new provision in the wills legislation that came into effect in 2013. Okay, all right. So I think we kind of answered this question, but I'll just sort of include it in my statement here. The question is how do I make a will? Basically, notary, lawyer. Or you can do it yourself.
or self?
Yeah, yeah.
So 3 ways.
Yes.
okay.
Yeah. So a will does not need to be witnessed by a notary or lawyer to be valid. It requires 2 witnesses. I mean, I recommend that people get it professionally done, but not everybody. It's not within everybody's means to go to a lawyer or notary to and pay the money to have one done. So it's important to know that there are other resources available. If somebody is going to do one at home, I do recommend they purchase a will kit, which you can get from, I think Staples sells them. You can buy it off Amazon. I think it still can be problematic though. So I do recommend for most people, if it's within your, if it's possible, get it professionally done.
Yes, and I agree with that. My brother and I both went through the self-will.
Self-counsel.
Oh no, pardon me. We went through the self-probate. Oh my goodness. Have it done professionally. That's all I can say. They are so picky on all of this information. I mean, like, if you say he instead of I or I instead of we, you are going back and forth to a notary to notarize every error in that document.
Yeah.
And by the time you're finished, there is more ink on that document than there is document.
Yeah.
Like, yeah, okay. So 3 ways: notary, lawyer, or self. Good one. All right. So if you went to yourself, like as a notary or a lawyer, you're going to go through the same process of the interview, the capability, determining assets, distribution. You go through all that process during that interview process?
That's right. In fact, I would say that it's the most involved interview.
Okay.
Those interviews are typically the longest for wills. Because I'm not just collecting that information and confirming capacity, but there's usually just like we've been talking today, and I'm explaining terms and what falls into the estate or not, and what doesn't. Usually these discussions are all part of that interview as well, because most people, not all people, but most people are not aware of these things,
Okay.
and for many people it's their first time doing a will. So I have to make sure they're aware of all these different terms and concepts and how they interplay with one another.
Exactly, yeah. And the most important part is the signing of the will.
Yes.
The person making the will has to have their signature. You cannot have a family member sign on behalf of.
I think you can under special circumstances, like let's say if a person is completely immobile,
Okay.
A person can sign on behalf of the will maker, but there's a very special procedure when we do that. So
Okay.
it's not something we see very often, but it's possible.
Okay, good to know, good to know. So again, this question like I have here, is it necessary to register a will? And I think you've answered that question as like no, the answer was no, but it's a good idea too.
Yeah.
Right? All these little things, like, and there again, like, in talking to you, like in this interview or going into your office, which we've done, you have made it so easy, so simple for us to understand. But behind the scenes, you are like that duck on the water. Up above, you are cool and calm. Down below, your head is spinning around, like, but we don't see that.
That's a good way of putting it. But that's pretty accurate.
Yeah, but you keep us cool and calm.
Well, that's part of my job. Is I got to try to take these, complicated and sometimes emotional things and try to make it as easy as possible for my clients.
Right, right. And again, this question always comes up, but because people are going to be watching this video and not the other videos, we're going to talk about this part again, undue influence.
So undue influence is anytime somebody's using a position of influence or power to try to coerce or pressure somebody else to do something. So a classic example might be let's say you have an elderly parent who is completely dependent upon one of their children to maybe bring them groceries, give them rides to their doctor's appointments, pick up their prescriptions or their medications, maybe helping them around the house. So and then if that child were to use that that dependence to try to either maybe get themselves added to the title of the parent's home, or added as joint on a bank account, or maybe to get a larger share from mom or dad's will. So those would be that's kind of like a one classic example of undue influence. So that's something we always have to be vigilant about,
Right.
especially when children are accompanying their parents, or anybody really is accompanying a will maker to an appointment. We have to try to figure out, who this person is, what's their relationship to the will maker, why are they there,
Right.
and are they, what's their intention.
Right.
Sometimes it's very innocent. Sometimes they're just trying to help out. They're quite often, a child will bring mom or dad to the appointment and say, I'm just, and they'll come in with them, and I'll explain the interview process, and I got to speak with mom alone, and they'll immediately step out there like, no, I'm just here to give her a ride, and to answer any questions. No problem, I'll wait outside.
Sure.
And they will sometimes themselves will say, I want everything to be equal, but whatever mom says, that's what goes.
Right.
And that's what I want to hear. We want to make sure that everybody's understanding who the real client is, and that is the will maker.
Right.
Not the person who books the appointment, not the person who pays the bill. It's the person who's going to sign the document. That's my client, and that's who I need to represent, and that's whose interests I need to look out for.
It's their name on the document,
That's right.
right?
Yep.
Yes. Whether they pay the bill or not is irrelevant.
That's right.
Yes, yeah, yeah. Okay. Last question. But for me, the most confusing question, but I got to ask it anyways. What is I'm going to get this word right, testamentary capacity?
So testamentary capacity is referring to the capacity required to make a will. So there's a few requirements that have to be met. And one of the big ones is, well, number one, they have to understand what a will is and what it does. They need to understand who their beneficiaries are, or who they ought to be. When we talk about, the whole leaving children out, even if they decide, they only want to give everything to one child, they need to understand that in a normal situation, all their children should benefit.
Right.
They just have to be kind of aware of that. They also have to be. They also must understand their assets and their approximate value. So be able to explain, what property they own, what bank accounts they have, the approximate values of those things. And they must be free and clear of any delusions that could prevent them from making a will.
Right.
So, and that's the most interesting one, because that doesn't necessarily mean they must be free and clear of all delusions, just delusions that could affect their ability to do a will.
Yes.
So they might think the sky is purple, and that is not. That doesn't mean they can't do a will.
Right.
It's more about if they come in and say something like, "Oh, my son's the devil and he's trying to kill me." That's more of a red flag for
Yes.
not meeting that.
Yeah. Exactly. Yeah, no kidding, eh? No kidding. Adif, this has been a marvelous interview. I've learned a lot. I'm going to go back and look over the more detailed, question and answers, okay, on the website to get a better understanding, because there's still some areas that are gray to me, and they need clarity. But for the most part, you have done an absolutely fabulous job on answering my questions, and I hope that the people viewing this video will take this more serious now than they ever have. Come to either see you or to a lawyer, or even to do a self-will. Get the process started. That, I think, is the key.
Yeah.
Right?
Yeah. Even a basic will is better than nothing.
Yeah, because there's just, again, we go by that rumor mill. We got to get away from that mentality that grandma knows best. Sometimes grandma makes a mistake. She heard it wrong or didn't understand it based on her education.
Yeah.
Right. So let's end the video there. I want to say thank you for doing all 3 of these videos. I've enjoyed it tremendously. I can't thank you enough for doing this. I hope you've had a good time, doing this as well. You've come across to me as a very knowledgeable person. I'm glad that I can call you my friend, a good friend, by the way. And let's hope that friendship continues. And maybe down the road, you know, maybe next week, who knows, we'll do a different video, like maybe on conveyancing, like whatever it happens to be that the public needs to know, because that's what this is all about. For your information type video, you know, informational videos. That's what I started off calling it, an informational video.
Sure, I'd be glad to come back anytime.
Awesome. Thanks again, Adif.
Thank you.
Really appreciate it.
No
Thank you
problem.
very much.
Thank you.